Hey everybody, and welcome to episode 7 of Washington Probate TV. I'm your host, Christopher Small, and this is the internet's most passionate show about probate. Welcome. You know, if you're here, condolences. You're probably here because you've lost someone, and I'm sorry about that. But we're gonna help you make this pain-free, this probate easy as possible, and hopefully give you some information that's going to help you get through this process quickly, to give you the time to mourn and or celebrate your loved ones, whichever fits sort of the way that you live. Okay, but I digress. Today we're going to talk about something that happens probably more often than you might think, and that is, what do you do if you open a probate as if there is no will, and then later on you find a will? This happened to me the other day. We had somebody come and talk to us, and they hired us, and they didn't think there was a will. We went through the process of getting the probate opened as if it were intestate, which means there is no will. And then once that happened, there was a personal representative named. They found out there was a social safety deposit box. Looked in the safety deposit box, and there's a will. So what do we do now that we have this will? Well, there's a couple things that you have to do. The first thing is you must file the will. Okay, you always have to file the will no matter what. It needs to be filed with the court so that it can be as long as it's valid. If it's a valid will, it needs to be filed with the court so that it can be just kept by the court. I don't know, it's a rule. It's the law. You have to file the will if you have it. So that's step one, is to file the will. And then really what you need to do is you need to do what's called an amended petition with will annexed. Okay? It's a total legal term. I don't even know where the term will annexed comes from. I didn't look it up or research it because I don't care. I just care about the rules. This is what the rules tell us. So basically what you do is you file a new petition with the court, and you let them know that, hey, we discovered this will. It says XYZ. If it says different things than what you've already done, then there's the potential that you will need to ask the court to appoint a new or a different personal representative, one that's named in the will, and or take whatever other action is required or necessary as a result of finding the will. But at the end of the day, that's what you do. Then once that happens, depending on what the will says, different things could change. If it does not provide for non-intervention powers, for example, that could be a problem. If it requires a bond, that could be a problem. Things could need to be changed. But in most instances, finding the will actually makes things easier. It makes them smoother. It provides more clarity, and it just makes things easier. I like to find wills. So that's it. This is a shorty, hopefully a goodie, but this does happen a lot. If you find a will and you're not sure what to do, if what I talked about made no sense whatsoever, and you've already opened a probate, feel free to call us. Call me, 206-659-1512. You can also email me, chris@cmslawfirm.com. We can help you sort of take care of it all, right? That's why we're here. We've done this a bunch of times, and we're good at it, and we'd love to help you through this process, right? So that is it. Like I said, if you have any questions, please let me know, and I will talk to you again really soon.